Hello and welcome to the Imprint Weekly Podcast, Summer Rewind Edition. We will be running back some of the many great guest interviews from our Imprint Weekly Podcast archive all the way up through Labor Day. I'm John Kelly, Senior Editor of The Imprint, a daily news site covering child welfare and youth justice around the country. You can read all of our coverage at imprintnews.org or check us out on Facebook or Twitter at the Imprint News. You can also sign up on our homepage for our free weekly and monthly newsletters. And for professionals in child welfare and youth justice, subscribe to our Youth Services Insider section for a closer look at news on business policy and practice. The Imprint Weekly Podcast is also a member of the SafeCamp Audio Network. You can check out our show page and all of SafeCamp's other great podcasts at safecampaudio.org on the web or at SafeCampAudio on all social media. All right, our first week of the Summer Rewind series, we're going to feature our interview in episode 7, going way back, with California Assemblyman Ash Kalra, who was the lead author of a bill that passed in the year 2020 called the Racial Justice Act, which at the time, still now, is a precedent-setting law in the area of sentencing. We get into the weeds of it a little bit in this episode, but basically, the law enables the defendant and their legal counsel in California to present evidence of racial bias as a means of pushing back against specific sentences for offenses after conviction. Now, you're going to hear Kalra mention early on that one of the charges or sentences he expects would be quite challengeable through the Racial Justice Act are gang enhancements. And one of the reasons that I wanted to include this one, other than the fact that we recorded it, when no one knew that this podcast existed, which now that I think about it, you got to give it to a California state legislator for joining a podcast nobody knew existed. One of the reasons I really wanted to put this out there again is because not too long ago, California saw a prominent example of exactly what Kalra was talking about there in April, and I'm going to read from the Stanford Center for Racial Justice's description of this case. A Contra Costa County Superior Court judge recently dismissed all gang enhancements in a murder case against 4 young black men under provisions of California's recently enacted Racial Justice Act. The court ruled that data showing racial bias in prosecutorial charging decisions and the racist text messages police officers sent about the defendants violated the California law. End quote. Also, since our conversation, an additional law has amended the Racial Justice Act so that it can be used to look backwards at old cases. At first, Kalra's first version of this law was just about judgments rendered after 2020, so going forward. So without further ado, enjoy our Summer Rewind conversation with California Assembly member Ash Kalra. Okay, we're joined today by California State Assembly member Ash Kalra, who represents the 27th Assembly District, which is most of eastern San Jose. Before becoming elected in 2016, he spent 11 years with the Santa Clara Public Defender's Office and also served on the San Jose City Council. And he is also the first Indian American to be elected to the California legislature. Kalra is the author of the California Racial Justice Act, or AB 2542. Which was recently signed into law by Governor Gavin Newsom and offers perhaps an unprecedented check on racial bias in the juvenile justice system and the criminal justice system. And Kalra was good enough to join us to talk about it today. So Assembly Member Kalra, welcome to the Imprint Weekly Podcast. Thanks for joining us.
Thank you so much for having me. Appreciate it.
So here's how the Legislative Council's Digest described your bill. I'm just going to excerpt kind of the most salient parts, so fill in if you think I missed anything big. It would prohibit the state from seeking a criminal conviction or sentence on the basis of race, ethnicity, or national origin, and it would additionally allow for a person who is no longer imprisoned to file a motion to vacate a conviction based on a sentence that was sought, obtained, or imposed on the basis of race, ethnicity, or national origin. And what I want to ask you to start out with is certainly no prosecutor or judge would ever say they sought a conviction or a sentence based on someone's race. So explain to listeners what exactly this means.
You're absolutely correct. We already understand that for the most part, prosecutors, judges, law enforcement. They're not going to intentionally or explicitly demonstrate racism or display racism. And so this is about going beyond that because we know that there are implicit biases that exist. The state of the law that currently exists prior to the Racial Justice Act, and it's the state of the law in every state in the nation, is that only intentional racism is something that can be challenged in a court in regards to a trial, in regards to sentencing, jury selection, what have you. This goes beyond that to really start to deal with implicit biases that exist in our criminal court system that are representative of our society. And so what that means for practical purposes is that if there's a particular county where the prosecutor is charging up certain types of crimes for certain races, or if you see a disparity that exists in terms of sentencing with one race versus the other, you can use that information to make a claim that my race is impacting the outcome of this case. In some cases, it doesn't necessarily mean there'll be a mistrial, what have you, but it may mean more equitable sentencing. Ultimately, we hope that it will cause prosecutors, law enforcement, judges, what have you, to be more thoughtful about how they're actually exercising their everyday practices so that they root out that implicit bias that exists in all of us.
Now, how long have you been working on this legislation? Obviously, it was a crazy legislative year all around the country. And I'm just curious how your kind of experience as a public defender sort of informed it.
Well, and to that point, I think I haven't necessarily been working on this specific bill, but on these issues for much of my career, as I worked as a public defender for over a decade before ever getting into the city council and then the assembly. This specific bill, AB 2542, we've been working on for almost a year. So it was in the late fall, early winter of last year when we first started discussing it with the coalition that ultimately became the sponsors of the bill. And so it's been quite a journey because of our pandemic-influenced year. And, it was introduced before the pandemic. It didn't get a hearing because of the pandemic and because of our shortened calendar for hearing bills. And then we had the torture and murder of George Floyd that once again reignited the fight for racial justice and liberation, particularly as it applies to our criminal justice system. And so we brought it back again on the Senate side. And we didn't know if we'd be able to get it all the way to the governor's desk. But it was again, a journey where it was on life support on more than one occasion.
Right. So this bill itemizes, quite a few scenarios under which a violation of the law can be established. I'm going to put them into two buckets. And again, correct me if you think I missed anything, but the first is kind of the behavior of parties in court, judges, jurors, lawyers. If anybody, if there's any exhibition of bias or animus based on race or ethnicity, that's actionable. And then there's the actual charges and sentences. If somebody is charged or convicted or sentenced in a way that's incongruous to people of another race, then that's actionable. Is that about the kind of two tiers here?
Yes, and I would say that the second tier that you refer to is going to make up, in my estimation, the greatest portion of challenges under this act. Again, to your earlier point, because you don't really see that intentional racism so prevalent, certainly not anymore, although it does happen, and there will certainly there will be some challenges in that regard. We're far more likely going to see challenges being brought by the defense attorney regarding how a case is charged, or ultimately how the sentencing is put forward. And so that's where you see a lot of the disparities that are the non-intentional but implicit biases that exist in our system. And by intentional, clearly, maybe not intended to be racist, but has racist outcomes.
So, yeah, I wanted to ask you about that second tier because, it strikes me, having read through the bill, that in order to make that case, you would need to be able to demonstrate with data, a real apples to apples disparity. Like this Black defendant with 2 prior convictions was sentenced to 3 years for aggravated assault, and the average length of sentences for exactly that same scenario of the white defendant is 1 year. Do you believe that right now that data exists in California? Are attorneys for those appealing under this law actually going to be able to kind of build that case with data?
Well, the data exists. It may not be in aggregate right now. It may not be really in a form that can be easily digestible quite yet, but that's what this bill will allow for. And keep in mind, even if you, after controlling for conviction history and the current offense, Black men who are convicted of felonies were 42% more likely to be sentenced to prison than white men convicted of a felony. Now that data exists. Now that being said, is it easy to get that the data that could account for a particular challenge across the board? I mean, there might be issues with that data collection early on, but it's worth it because this is really, a lot of what we've been dealing with, especially since the continual rise, and especially this year, the Black Lives Matter movement and the call for racial justice. A lot of what we've been dealing with is kind of around the edges, dealing with police conduct, dealing with getting rid of enhancements and what have you over the last couple of years that show disparate outcomes. This is a bill that's actually going to get to the root cause, and that data is critical to get to that root. So will it take some time and energy to do that? Certainly, especially in the first couple of years. But ultimately, what this will lead to, and I'm very optimistic about it, is behavior change on those that are doing the charging, on those that are sentencing. I really believe that because they're going to get challenged and they're going to start to recognize, wait a second, I can't do business as usual because business as usual has led to really, really bad outcomes. And so we're trying to fix it by just creating better behavior. But initially, absolutely, there will be, there will be some cost and time involved in making sure that data is provided to the defense attorney and the prosecutor when appropriate.
Now, what happens if somebody succeeds on this law? Walk people through. You succeed in proving that racial animus or bias was part of your case. What happens next for a successful appellant?
There are different remedies, including a mistrial where they get an opportunity to have the case tried again. But in some of the remedies, including in sentencing or some of the enhancements, the sentencing can be adjusted or the enhancements can be stricken or reduced if it is shown that race more likely than not played a role in that outcome. And so let me give you a practical example where someone can make a challenge. Let's say there's a string of auto burglaries in a particular county, and 90%, and let's say you have equal number of white criminal defendants and equal number of Latino criminal defendants, but 90% of Latino defendants are being charged with a gang enhancement, while 2% of the white defendants are being charged with gang enhancement. Well, that's a legitimate claim where a defense attorney can say, hey, I think that the race is involved in the charging of this enhancement. A judge can look at that data, look at the case, look at the facts of the case, and make the determination, you know what, I agree. And then the gang enhancement can be stricken by the judge, which right now a judge does not have the authority to do. And so the outcome isn't that that person gets away with the auto burglary, it's that they actually get charged, tried, and if convicted, get sentenced in a way that actually fits the crime and is appropriate, doesn't let them off the hook, but doesn't unnecessarily punish them in a way that white defendants are not being punished.
So most cases in court end up in a plea deal. I was curious, does that matter as far as this law is concerned? If a plea is involved, does this law still apply?
It could on appeal. It depends. But what I would say is that it's more like what would be appealed is a determination by a court that the charges being brought don't have any racial bias or discrepancies that require a closer look at the charges. So to put that more simply, if you have a DA that charges a defendant X number of counts, enhancements, what have you, and pre-trial, while the case is still being discussed for settlement, the defense attorney brings a motion to have some of the charges reduced or enhancements removed based upon the Racial Justice Act. A judge can decide in favor of the district attorney, and then the defendant can plead guilty based upon losing that motion. They say, well, you know what, I'm going to plead guilty rather than go to trial, but they can appeal that decision at the appellate court. They can appeal it prior to a plea as well. But the idea, I think in the ordinary course of business, that appeal would happen before a plea. But I can see scenarios where even if there's a plea and a sentencing, that they can challenge the sentencing after a plea based upon racial discrepancies, what have you. So there's different kind of timelines along the procedures of a criminal case where you can make that claim. And just by pleading guilty alone by itself wouldn't necessarily say that you can't also challenge racism involved in the conduct of the case.
Hi, my name is Christy Rennick, and I'm co-executive director of Fostering Media Connections. If you're enjoying the Imprint Weekly Podcast, please consider supporting it and all the other great work our team is doing. Every day, Fostering Media Connections is reporting on important child welfare and youth justice news through the Imprint, our daily news site. We're reaching foster and kinship caregivers directly in their homes with our award-winning magazine, Fostering Families Today. We help youth with lived experience share their stories and views through our Youth Voices Rising program. And we recently launched Safe Camp Audio, a podcast network featuring a wide range of shows on youth, families, justice, and the social safety net. To support our work and the amazing people who do it, please visit fosteringmediaconnections.org/donate. That's fosteringmediaconnections.org/donate. Thank you.
Now, the imprint mostly covers child welfare and juvenile justice. I'm curious how you see this law impacting the juvenile justice system in particular, where the court process, doesn't work quite the same.
Yeah, that's been a big issue over the last few years. It was certainly an issue when I was a public defender, how much control the courts, the government has over a juvenile when they're being accused. And so, however, that being said, this Racial Justice Act applies to all criminal cases. So juveniles will have the opportunity to also challenge it. And we know, especially when it comes to gang enhancements, when it comes to discrepancy in treatment, and I know we've all heard this anecdotally and the data shows it as well, that if there's a fight at a school, for example, especially if it's a wealthier school versus a lower income school, a Black accused is far more likely to end up in the criminal justice system as a defendant than a white person who's accused. And so that absolutely directly relates to our juvenile justice system. And they would have the remedy, or at least they would have the tool of the Racial Justice Act as juveniles as well.
Am I gleaning correctly from your answers that gang enhancements are a quite prevalent point of departure?
Well, I think that's absolutely one, the way the gang enhancements are used, but also I think just whether someone's charged or not, what they're charged with, sentencing has enormous discrepancies. For example, in California, a Black man's over 8 times more likely to be incarcerated than a white man. But that's a worse racial disparity than Mississippi, which has a disparity of 3-1. Louisiana has a disparity of 4-1. Now, none of those disparities are good. But the fact that California is far worse than Mississippi and Louisiana tells that we have a problem in what the outcomes of these cases are. So not just gang enhancements, but that's just one clear example where I certainly think that it has racial disparities. But I think that it applies pretty much across the board in our criminal justice system.
So one of the, I guess the chief opponents of your bill was the California District Attorneys Association. And it seemed like one of their main criticisms was the lack of definition on some terms, more serious, similar, disproportionate kind of terms within the law. How do you respond to that? Do you think that it's appropriate for judges to be making those determinations sort of case by case without structured definitions?
That kind of terminology is throughout our justice system, both civil and criminal. What's a reasonable person? We get jury instructions that somehow that try to describe it. What is beyond a reasonable doubt? We have jury instructions now that try to describe it, but these are all kind of difficult things to really pinpoint. And so just like with those terms of art, so to speak, in our legal terminology, the terms in this act will also get better defined as time goes on through appellate decisions, through Supreme Court decisions. As one person will, a DA will certainly appeal some of the judgments, the decisions of the judges, and defense attorneys will, and that's how law is made. They know that. They know that that's how these terms get defined. And so to say that a term is vague or hard to define, well, that's part of the job of the attorneys, is to make the case as to whether something falls under a certain category. And then it's the job of the judges to agree or not, and eventually the appellate court and Supreme Court to further hone in on the definitions. And that will happen just like any major landmark legislation or court case. That's what our courts do, and they're very good at it. And eventually there will be jury instructions that will be part of the Judicial Council recommended jury instructions that will deal with the Racial Justice Act. There'll probably be a first round of it this next year, and it'll get changed as the years go on, and they'll be challenged. And that's how our court system works. The DAs know that.
How about the law itself? I mean, it jumped out to me as a pretty unique approach. I don't know if you built this off of work that maybe has been done in other states, but do you expect this law to get challenged pretty quickly, just on its face?
Anything that's meaningful and actually deals with systemic change will get challenged. I mean, we know the DAs are going to challenge it. They've been challenging it. And one of the things they said during the Senate Judiciary Committee hearing or Senate Public Safety hearing is that, we already have remedies, we already have safeguards due to the Constitution, it's already against the law. Well, clearly those safeguards and remedies aren't working. And so if they believe the status quo is okay, they're wrong. And we know the status quo isn't okay. Not only those of us that are legislators or those of us that have worked as public defenders, there are millions of people out in the street right now that know the system isn't right. I mean, they may not be able to articulate, we need to do this, that, and the other in terms of legislation, but they know that we have a criminal justice system that has a racism systemic within it. We're trying to root it out. I really wish that the DAs Association would support us in that. However, there are DAs in support. San Francisco DA Chesa Boudin, Diana Becton, Contra Costa DA, George Gascon, who's in the runoff and could be the next DA of LA, as well as Tori Verber Salazar from San Joaquin County wrote a letter of support. And there's actually a new prosecutors association, the Prosecutors Alliance, that wants to be part of the solution of progressive change that actually creates real public safety, not the outdated 20th century model that the California District Attorneys Association has, that you just have to lock people up for as long as possible. And we believe that DAs are the ones that have all the wisdom to figure out how to do that. Well, that's absolutely not the case. And our history has shown that's not the case.
Assembly Member Ash Kalra of the 27th District, thanks for joining us on the Imprint Weekly Podcast.
All right, thank you so much.
Thanks for joining us today for this Summer Rewind edition of the Imprint Weekly Podcast. The Imprint Weekly Podcast is a production of the Safe Camp Audio Network, which is a division of Fostering Media Connections. Please visit safecampaudio.org on the web or at safecampaudio on all major social media. This podcast is produced and mixed by Christine Adjoko with music by Luke Giroux and Cyrus Elia. If you enjoyed this episode, we would love it if you consider subscribing or giving us a 5-star rating on Apple, Spotify, or wherever you download your podcasts. And we would greatly appreciate if you would consider supporting our work here on the podcast and in print. Small donations from our listeners and readers go a long way towards helping us grow and cover more great stories in child welfare and youth justice. To support us, it is very easy. Just visit imprintnews.org/donate. You can follow The Imprint on Twitter and Facebook by searching the handle @TheImprintNews and visit us on the web at imprintnews.org. You can email us at tips@imprintnews.org. I'm John Kelly, and we'll see you next week.